I'm a senior procurement consultant working at TLT. Over the course of my career, I've jumped through a number of different roles. So originally I worked in the construction industry. I then spent 12 years working in local authority. And then more recently, I joined TLT, providing technical and practical advice and support to local authorities. In this session, we're going to look at regulated below threshold procurement. What are the rules around running a competition when we're looking at below threshold contracts? Can a contracting authority limit the number of suppliers who can participate and, more pointedly, exclude some? Can an authority negotiate in a below threshold procurement? And can you challenge the outcome of a below threshold procurement in the courts? So we're going to start by just understanding exactly what is a regulated below threshold procurement. And there are three different limbs here for us to work through. It doesn't matter which order you work through them. So we're going to start with, is it below a threshold? And you'll see there on the screen, there is a specific threshold for goods and services. And these differ as to whether it's a local authority or a central government body, and a different threshold then for works. If you start looking at concessions or utilities or light touch regime, again, you start looking at other thresholds. But for the purpose of today, we're going to stick with goods and services or works. Assuming then that the value of the contract is below one of these thresholds, the next thing is to say, is it exempted? Now, for some contracts, once they go below this threshold, in particular, if it's a concession contract or it's a utilities contract, then there are none of the rules in the Act that apply. Likewise, if it's an exempt contract and it's therefore exempt from the whole of the Act, if that contract is above or below threshold, then none of the rules apply. And then finally, the last check is it a school, a Northern Ireland authority, or a Welsh procurement arrangement? Again, if it's one of those, regardless that it's below threshold, the few rules that do exist in the Act don't apply. So they can run those procurements as they wish. Now, an important note is that as of the Act coming in, those values include VAT, which is a bit confusing because in most cases, local authorities don't pay VAT. But from the point of view of the value of the notice and what rules do or don't apply, they must be calculated with VAT. And things that are covered in the Act as only applying to covered procurements, such as the new objectives, don't legally apply to below threshold, but it would still be best practice for the authority to adopt those objectives. So let's assume for a moment it is regulated, i.e. yes, it's below one of those thresholds, but it's not exempted and it's not covered by being a school. Let's assume it's regulated. So there's very little in the Act that tells you what you can and can't do. But that doesn't actually mean that authorities can do exactly what they please. Every public sector has some form of standing orders or regulations, just in the same way as a company that is becomes a company on Companies House and they have to have articles. Authorities too have to have some form of standing orders or regulations. Now, for local authorities, this is the Local Government Act of 72, and it stipulates they must state how they will contract their requirements. And then when we move to the Local Government Act of 99, it states that they must demonstrate that they are getting value for money and best value. So although there's no absolute rule that says you must advertise at this threshold, contracting authorities need to balance the cost of a process with the benefits that that process will deliver. So if it costs more to run a procurement than they might save, then they shouldn't be running a procurement. But that is for them to determine and justify as part of their own rules. Within these rules, which they will have to publish on their website, they should also include how suppliers can put themselves forward for when, for example, they are seeking quotes as opposed to advertising an opportunity. And throughout this process, when they're trying to decide how they're going to do things, they need to be practical, They need to think about what resources that they have available to them and whether they have the expertise to actually do that. And sadly for construction, a lot of local authorities now don't have much construction skills in-house. So thinking again about how we are designing these below threshold procurements and whether we can limit the number of suppliers, the simple answer is yes, and the more complicated answer is no. So if we look at it from the point of the Act, under the Act, it says for goods and services contracts below, for local authorities, it's 213,000. Authorities may not have a discrete conditions of participation stage. So they can't have a procurement where they run an SQ and take through the top 6 suppliers and then get them to tender. That is not permitted for goods and services. However, they can say for a quotes process, we are going to identify just 3 suppliers to invite to submit a quote. That is perfectly acceptable. And how they choose to identify those 3 suppliers will be down to them. And depending on who they are and their membership, it may be that actually they say we're going to identify suitably qualified suppliers through a portal like Constructionline. If we then move to works that are above 213,000, but below the threshold at which it becomes a covered procurement, so 5.37 million, then we can have a discrete conditions of participation stage, so a discrete selection questionnaire. We state this in the advert for the procurement, and that selection can be based on legal, financial, and technical ability. So exactly as we've got in the Act now. And for those of you that keep up with the PPNs that that are published for the government, then you will see that the latest one, which is PPN 0324, now suggests that authorities should be using the Common Assessment Standard questionnaire for determining the suitability of suppliers. Now, that's above threshold, but if you're using it below threshold, then I would strongly suggest that you are using a modified version, because 240 questions on a construction contract of 250,000 would not be proportionate. And again, if your standing orders actually say we can select 3 suppliers to provide quotes up to £1 million, which they can, then yes, again, we can limit the number of suppliers that we invite to participate in the procurement. And of course, if it's an exempt or excluded regime, as we identified on the previous slide, then again, the authority can go about appointing a supplier in whatever means is appropriate to them. And that includes limiting the number of suppliers. Contracting authority negotiate in a below threshold procurement. Now, we've already mentioned that the rules that apply to covered procurements do not actually apply to below threshold. However, they are still best practice. And so we absolutely should be applying rules of equal treatment, integrity, and information sharing. And we should be following the same principles around conflict of interest. So identifying, mitigating, and monitoring those potential conflicts. So with that in mind, let's work through the examples that I mentioned earlier. If we're getting a single quote, then obviously we're not advertising that. We're identifying a supplier to work with, potentially walking them around a building site, pointing out things that need doing. And that conversation allows us to negotiate with that supplier, subject to that being what they've written in their standing orders. So we absolutely can. And we might say, well, we've got a budget of 30,000. What's the most we can achieve, or what products are going to be the most cost effective, etc. So yes, in that one, if that's what's in your standing orders, then you can. As you move into getting 3 quotes, we've now got 3 suppliers to deal with. So we've got to be fair, we've got to be transparent. So if you are going to engage with them, if ideally you feel there's going to be some form of need for negotiation, then we need to be setting that out in the procurement documents, and we need to check that the authority has that covered off in their standing orders. And then in doing that, it might be that we send out a tender pack or a quotes pack, ask them to put in a price. And we've got the ability, once we've got that, if there's something that's not quite clear or if it's coming over budget, that we can then have some form of negotiation. Once we move through to what I call a simple tender, so that is a more formal process that we advertise. At the moment, we would be advertising that on Contracts Finder, but once the new act comes in, it will be on the same portal as everything else. We need to get a bit more careful involving negotiations into those processes, because it becomes so much more complicated to demonstrate that audit trail of compliance. Once an authority has run a below threshold procurement, let's say they've had a bit of negotiation in there, there's only been 3 suppliers, etc. What happens if you don't win and you're not happy about it? Well, the first point to note is that Part 9 remedies does not apply to below threshold procurements. So you cannot bring a challenge for below threshold procurements in the way you can for an above threshold procurement. Now, that isn't to say that you can't seek to try and hold an authority to account. And there are a few ways that you can do this. Now, the first way, most simple, is if you're unhappy, is to send a complaint in to the authority and say, we don't think you've done what you said in your procurement documents, or you haven't followed what's in your standing orders, and we think that the outcome is wrong. Obviously, try to keep that fairly friendly, because at this point, there could have just been an honest mistake. Equally, what they've done, they could believe is completely correct. And you might find that you get a letter back from them saying, thank you, but we don't agree and we're going to proceed. And they can, and that is absolutely fine. If that doesn't get you anywhere, now within the Procurement Act in Part 10, we now have this section on procurement investigations. Now, this is replacing the current Public Procurement Review Service, which replaced the Mystery Shopper service. And you can file a complaint against an authority to this service. And if it is in scope of what's permitted under the Act and the service itself, then they may indeed conduct an investigation. They won't look at things like, well, they haven't included public benefit, or they've not considered their duty to SMEs, etc. It will have to be on, really poor conduct. They've not applied the award criteria the way they said they were going to, that type of issue. If the review turns out that they agree that the authority hasn't done what they should have done, then they can issue what's called a Section 109 recommendation. And the contracting authority must have regard for this. Now, unfortunately, have regard doesn't mean they actually have to follow it. If they look at it and think, okay, well, we take that on board, but we don't agree, there is nothing that you can do. They've had regard. Now, if it's a really important thing, the review unit may ask for a progress report to force the authority to have to really think about it. But this progress report could end up with them writing back to say, we've thought about it, we don't agree, and we're not doing anything. In that event, there is nothing more left you can do, unless you can say that what they've done is contrary to their own standing orders. So if, for example, they say that under their standing orders that they will advertise at a certain threshold, and they don't do that, and there's no ability in the rules to have an exemption from that, then you can seek a judicial review that they are not complying with their own rules. But this won't have the same effect as a formal challenge. So if you make this complaint and it's investigated before the contract is signed, then the authority would be required potentially to rerun their procedure. But if it's after the contract is signed, then they don't have to terminate that contract and there are no damages. So reputationally, it's something authorities want to avoid. But from the point of view of fixing what you see as a wrong, unfortunately, it won't do that. So it's not necessarily quite the same fix as bringing a legal challenge. So there are just a few other considerations that I just want to bring to your attention, because local authorities in particular do a lot of below threshold procurements. So for smaller SMEs, these are a really important area. So If a contracting authority starts with something that's a below threshold procurement and they modify it and they modify it, and then it goes above the threshold, under the Act, this will then make it a convertible contract. And once it goes above that threshold, all the rules of the Act will then apply. And we start having to look, was it an unlawful direct award? Actually, do I want to challenge? Is there grounds, etc.? So the minute it goes above that threshold, then the rules of the Act apply. Where the authority is putting out an advert, so in the examples I gave you, this was a simple tender, then there must be a tender notice published on the central digital platform. At the moment, we believe that's to be fined a tender. If they award a contract, regardless of how it was procured, there must be a tender notice, so a below threshold contract details notice, so 30k or above, including VAT, must have a notice. In all procurements, even those below threshold, there is an implied payment term that suppliers must be paid within 30 days on the date on which the invoice is received or deemed acceptable. And then finally, there is a duty for the authority to consider how they can work with SMEs. Now, it's a duty to consider, it's not mandatory, but one way in which they can do that is to look at structuring their procurement into different lots or designing the procurement where SMEs can be involved in the supply chain. So hopefully you will have found that a useful session on below threshold procurements. If you have any questions, please do not hesitate to contact myself or any of my colleagues. Our details are included on the slides. And I'm just going to take a quick opportunity to plug our new Procuring 360 offering, in which we can provide both local authorities and public sector suppliers with support in getting ready for the Act. And as you can see from this slide, we offer not just legal, but technical consultancy and practical support. And so please do check out our website to find out more about what we, the team, can provide you with, and if there is any further support that we can provide to you in preparing for the Act. Thank you.